days before the day of filing. Abutters shall also be identified on any plat submitted to the board. The application shall also include the name and business address of every engineer, architect, land surveyor, or soil scientist whose professional seal appears on any plat submitted to the board. Since construction of any structure near streams or rivers downstream of a dam can increase the hazard classification of the dam established by the Department of Environmental Services, the application shall identify the nearest dam upstream and include the name and addresses of the dam owners.
Well said.
So I think the relevant part here was
Something about butter.
all abutters as indicated in the town records for town small t, town records for incorporated towns or county records for unincorporated towns or unorganized places. So I think that if it's abutters as indicated in some towns' records, not necessarily our town's records.
So we should change it from capital T to lowercase t, and that should cover
I
it.
think it might.
I think that's getting a little too much. I mean, the way that it's stated now, if the applicant is applying due diligence and trying to notify people, notify all abutters according to the records of this town, they can't be held responsible for the inaccuracies of other towns. As long as they're trying all due diligence to fulfill obligations for the application, they should not be penalized for the inaccuracies of other towns.
You know, you just brought up a great point.
That's true, but...
I do that once in a while. I get
Is
lucky
that-
sometimes.
Well, I think
In
that-
this bizarre
Scare
situation,
yourself.
should we be having, I mean, this is truly
It's one
Just-
property,
one property with one little few 100-foot boundary line.
and always...
And they should be notified, absolutely.
Well, yes, it's the law, but the other part of it is, who certifies it? Does our person have to certify it, or do we have the person go to Wakefield? I mean,
records that we
Middleton.
have are accurate, and if the
Yeah.
person following our records, using the resources that we provide for our residents, they're following all due diligence, and they should not be penalized if the records for other towns are inaccurate, or they haven't duly reported to us any changes to our
We
butters.
have to
Cliff?
make sure that town is...
At this point, because he has abutters in both towns, and by law, he has to have those records certified. You may want to add a different or an additional phrase in there that states that not only by our assessor clerk, but by any abutting a town's assessor clerks. So therefore, for his abutter that lies in Middleton, he has to take that form to Middleton and have their assessor clerk verify that that address is correct.
But
Yeah.
in doing so, are we asking for undue duress on the applicant?
Absolutely
not.
Following?
No.
That would be my question about
Nope.
that.
Anytime a wireless tower is built, a cell phone tower, any kind of tower is built in this state, if that tower abuts properties in different towns, all those abutters have to be notified.
Yes.
And it's the company's responsibility to follow the procedures and to verify and to get certification of all the correct butters addresses before they move forward with the planning board in the town that they're wishing to build it in.
And that
But here's the situation with this particular property that's in discussion, and let's not kid ourselves, we're talking about Moose Mountain. All the butters had been notified. It was an arduous process of making sure they knew that they were going to be doing special activities. As long as our records do show that John Jones owns that one property abutting, and we're following those records with a conditional use permit, do we need to go to that extent to
You
follow
have to
through-
follow the letter of the law.
Yeah.
This
But
town
where it's
cannot
conditional
be-
use permit, and there is
This town
attempt
can be
to
more
contact.
stringent than the state law, but we
Absolutely.
cannot be more lax than the state law.
As
And
the
the
sta-
state
as the
law
state-
states
Yeah, as the
they
state
have
agencies versus
to
federal.
notify the abutters.
Rob's been real patient. Go ahead, Rob.
So I think to address Jim's concern, which I think is it's a valid topic, I think that it's important to understand that we don't have to have any requirements about an abutters list. And however, if the abutters list is wrong, if there's an abutter who doesn't get notified, even if we go through the whole process,
We got the same situation with Moose Mountain.
even if we go through the whole process, we approve it, they're in business for 5 years doing it, that abutter who didn't get notified can go to court and have that whole thing wiped out, right? And they will win because they didn't get notified, no matter whether it was even if our assessor clerk certified it as correct, or Middleton's is certified as correct, if that abutter didn't get notice, it's gonna get overturned.
But he's not.
So what we're trying to do here is just not waste our time, right? We want to put a check in there so that we're less likely to have something overturned because of a technicality about abutters by having our assessor clerk just validate that the list appears, to the best of our ability, appears to be correct.
Yes, absolutely. I do agree there, but the point that I'm trying to make is that he's not making any major alterations to the facility at all. He's just asking for a temporary use.
Doesn't matter.
Doesn't matter.
That was why, where we
But-
have to go into that
Yeah.
detail.
But if his subdivision goes through and he does put off that into conservation easement, that nullifies this conversation
He's his
anyway,
own butter.
because he's his own, those properties are no longer the same property, and the property in the easement would now become the abutter, and he wouldn't have any abutters in an adjacent town. Okay, but you can't, we don't know if that's gonna go through, we're dealing with here and now. You have to notify and do your due diligence in every town that you abut, period, end of story. The hardship's on the applicant, not on this board.
Yep.
I can't make a motion because I'm not sitting, but I would suggest that somebody make a motion or get this change. Just get the capital T changed to a lowercase t. And I think that makes it unambiguous that it is town records. It actually mirrors the state, the RSA wording. If you read both, it would be clear that we were pulling that phrase out of the RSA's.
Our intent is clear.
And it'll be totally clear. And I think that George said that he pulled this page from somewhere else. I would suggest we also look at making the change where this got copied from as well.
Right. Where this came from originally was the Rules of Procedure Common Application Packet. I think that's what the name of it is. But one of the things we talked about in the Rules of Procedure Committee last year that came forward to this year is that whole application is a little goofy. There's some things that are missing, and that application needs to be updated.
Things that are in that application is
They're not things that are legally incorrect. It's just that we're trying to do.
It should be separated.
Right. There's just too much going on. We're trying to do too much with one application, and we live through the process. We know.
I'll move that, I want to make sure I understand this, Rob. This is on page 6 of 6, under 1, instructions. The second line, in town records, the small t, not a capital T.
That is what my suggestion is, yes.
And I'm reading very quickly, and that's the only time I see that T question on that page.
I believe that's
Am I right?
correct.
So is that a motion?
Yes, that's a motion.
Is there a second?
Second.
Any further discussion? All in favor?
Aye.
Aye.
All opposed? Any abstentions? The ayes have it.
Good job.
That's some good thorough debate.
I do have some questions about this now that I've read it.
Sure. Please go ahead, Cliff.
In regards to site plan review, so you're saying that for all issues, anything that he does up there changes?
You're talking about page 2 of 6.
Yeah, 2 of 6, sorry, where it says with regard to site plan review, that you are going to require, no matter what, a site plan review.
That's what we were informed by the attorney. At the end of the last process with Moose Mountain, I remember she said in one of the meetings that any
Ready?
future additional use would require site plan review. That would be including any conditional use.
Any new?
Correct.
Okay, but here's the kicker. The way that this is read,
Mhm.
say, this year, Mr. Bordeaux, and this is all hypothetical, of course, requests a special use condition for XYZ.
Which is.
It expires in 1 year.
Mhm.
He doesn't renew it that next year.
Is that why the?
It's in our conditional uses, it's all,
Yep.
everything, but he doesn't renew it the next year.
Mhm.
You make him go through the site plan review for that.
I think
Hang on.
that's at the discretion, isn't it, of the
Hear
board?
me out.
Mhm.
And then the following year,
Yeah.
he decides to do XYZ again.
So he's got a gap of a year.
Are you gonna make him do a whole new site plan review for that?
For the first time, I believe the board would.
Okay, but that's not the way this reads.
Yeah, this reads that even if he's renewing,
He has to
he
go
has to
through
go through the
site plan.
same cycle. That's how it reads.
Isn't that how it read?
Yes. Oh, yes.
Which paragraph is that in? Oh, on page 2.
Where did you mention
It says, if you're requesting the introduction of a new conditional land use on your property in the REC1 district, a site plan review by the planning board will be required. So that's specifically new. Is that the sentence you're talking about, or is there somewhere else?
No.
Cliff, where are you actually? On page 2 or 6?
I started reading right after the bold with regard to site plan review. If you are submitting this application requesting the introduction of a new conditional land use on your property in the Rec 1 district, a site plan review by the planning board will be required.
You're right.
Is that what you guys were talking, is that,
That's, yeah, I misread,
Explains
sorry.
that a little more clearly, but
Oh, we want to make
Then
sure we
then
get
the question
it covered.
becomes, if he doesn't do it for a year and he puts it back on the board a year later, so there's a year gap,
it's new,
does that constitute a new conditional use
it's new.
permit and he is going, or a new conditional
Why don't
use?
they, we're in a position to clarify?
Sure you are, that's what this board does.
No, not hypothetical.
Absolutely, this board is meant to look at hypotheticals, that's why we're called a planning board. You plan for the future, that's all hypothetical stuff.
We're setting our customary
Cliff,
practices right now.
George just caught the last sentence there. It says, renewal requests for conditional use permits may not require a site plan review.
oh,
The last sentence of the first third of the, with regard to site plan review.
okay.
I think though that Clifton was asking about the question of, they have it, they let it lapse.
Yeah.
And they want it again. The want it again, I don't think is a renewal. I think that's a new, it's a.
Yeah, because there's a year lapse in
Maybe
between.
it lapses.
Right.
Right, and so I think it's new. The way this reads, and we can decide that we don't like that, but the way this reads would be that it would require a site plan review.
We didn't address renewals in terms of that specific, and that is something maybe we should address, because that's a very good point, is, a lapse. If there's a lapse of a day, is that a renewal or a brand new one?
It would have to be a renewal.
So-
No, if it's lapse, if there's a lapse.
Yeah,
it would have
if
to be
there's a,
renewal.
yeah,
You
that's,
have- you
So
have time limits.
the only thing that you
If
have
not
to
renewal,
do
then 1
is
year
put
from
in
that
there,
day,
may
conditions.
require.
and that's what's in there.
We should
No.
specify that.
Renewal requests for conditional use permits.
No, what I'm saying is, on the first line, a site plan review by the planning board will be required. Instead of say will be, may be required.
No, it is required if it's new. That's for sure.
But now you're back to this, because
Right.
there's a lapse of time,
Mhm.
and he goes up with that same
Yeah,
that same thing that
exact
you've
same
already
thing,
done.
sure. Yeah.
Well, no, it's
But
the.
Because there's a lapse, it's now a new conditional use.
No.
It's a change in use, it triggers the site plan review.
Yeah,
It-
if there's a lapse, that's what he's saying, that's exactly what he's saying.
This
If
is
there's
my
a lapse,
understanding,
it's a new-
is
it's a-
with the conditional uses, and we've never actually gone through this, so, this hasn't been vetted by the attorney.
Well, it's better be hammered on down.
Yeah, I think we have to.
We go through the process, we approve the conditional use goes on for some time period. Should the board choose to put a time limit on that, whatever the length of the time is, that runs out, that use goes away. That is no longer an allowed use, because it was a time-limited permit, conditional use,
And he has to apply for a renewal or
or a brand new
let it
use.
go.
I think it's not likely that they would let it go, but I think it's a good point, because it could happen, as to what this scenario requires. This might be one for the attorney. I think we can debate this forever,
So
but
do you remember where in our regulations that there were like 3 things that triggered the site plan review? There's like, where
yeah,
is that?
I've got that. Hold
So I
on.
think one of those was a change in use,
Right.
right?
Change in
And
use.
so
Right.
I think that because of that,
New use.
if it expires, that use is no longer permitted. They want to get it back again. It's, I think inherently a change in use. I don't know how we get around that.
Here we go. Site plan review regulations from 1997. So these are the 97 ones. Okay, Article 5, types of development requiring a site plan review. No site plan approval shall be required for one-family dwelling units, agriculture, as defined by RSA 2134-A, or associated accessory uses. An applicant